of entering into court, we need to understand first the jurisdiction that has been set. So we need to understand, as we are helping the client to be able to stand in court, we need to distinguish between the criminal offense and also the criminal jurisdiction and also the civil jurisdiction, because these jurisdictions, they have got the difference in the way the matter has to be handled in court. In a criminal jurisdiction, they say you need to prove the case beyond reasonable doubt, which means that the case has to be 95% possibility that a crime was committed for one to be convicted. In a civil jurisdiction, it has to be 5% or 50 and above. So that is what makes a difference. So when it comes to the evidence that has supposed to be brought in court, and also how the court is set, the criminal court and also the civil court, how these courts are set and how the jurisdiction is done. So that is what we are going to look at. So first and foremost, we are going to look at the difference between the criminal and also the civil jurisdiction. Then I'll also come and now look at how we are going now to start and do what is involved in the criminal jurisdiction. Who are the players in the criminal jurisdiction? And from there, that's where now we're going to look at all the process in the criminal jurisdiction from arrest up to appeal. So those are the things that we are going to look at, and I want you to be attentive and to be with me as I bring out the skills that we need to have as paralegal counselors. Remember, our main duty as paralegal counselors is to help somebody to stand before court and or to guide somebody on how they should be able to stand in court. Now, let's look at the procedure or the process for a criminal offense or a criminal case to be brought before court. First and foremost, there must be a suspicion of an act which is called an act of crime. So there must be suspicion in that act. So there must be somebody who should be who is called a suspect. So a suspect is somebody who is accused of having committed a crime. So now, if there is suspicion of a crime, mostly what happens is that the case is reported to the police. And when the case is reported to the police at the inquiry, the police officer who is there writes the complaint from this who is called the complainant. So the complainant is the one that reports the case to the police. Now, the police, they are able to determine if that case is criminal or if that case is civil. But in most cases, you'd find that the case, the police will handle every case, because mostly the people that we have, they don't understand what is a civil case or what is a criminal case. So even when they need compensation, they need to get the relief from what they want, or they want to get a debt or whatever, people opt to go to the police. Why? Because sometimes it is because they don't understand. Then the other reason is that they want things to be done fast, because the police seem to do things fast, even something that is not in their jurisdiction. So that is the reason why people report the matter to the police. Not only that, I think the police are the first is the first department that deals with disputes, because it maintains order in the community. So when there is a dispute, there can be other crimes that can be committed because of that particular dispute. So it is right that people all report their issues to the police. Now, when the case is reported to the police, for example, maybe one has been assaulted, so that case is reported to the police. And now the police, they are going to do the investigation, preliminary investigation. They are going to have the inquiry about that case, what happens and how it happened. Now, the police, they are going to be able to they are able to look at the evidence that can lead into the arrest of this person. For example, in the case of assault, they will require the medical report. Now, when the person, the accused, is arrested, there are things that are supposed to be done. Number one, this person has the right, the accused has the right, and according to our constitution, the constitution of Zambia states that a person must be able to appear before court within 24 hours. And it can go to 48 hours for reasons. Sometimes it may be because of the weekend. But I want us to know that it's less happens like that in Zambia, because the police, they have got powers to defend themselves why they have taken some action. They may say we were investigating or doing what, but a person must be brought before court within 24 hours. And the police, they have to, they are mandated to investigate the matter before they arrest a person. So that is a procedure that should be taken. So, but in a case where that doesn't happen, as the paralegal counselors, when a report comes to you, you have to make a follow-up to the police and also help the client to be released. It's either on bond or he has to be released where the matter is not thoroughly investigated. So they have to do what is called police bond. Now, in the the case has been written and the investigation has been done. So during the investigation, what happens is that the police will interview the complainant and also will find the witnesses to the complaint. There must always be the witness who should be able to concur with the complaint that is brought before court. Then the other thing is that the evidence has to be set. So the police sets the evidence, and then they hand over to the prosecution. So the prosecution is a department. Like in Zambia, we have got Zambia Prosecution Authority. So the Zambia Prosecution Authority, they handle all the criminal cases. So these are the lawyers these are state lawyers that deals in the criminal offense. So the complainant automatically is given a lawyer who is called the prosecutor. So now, when the matter comes in court, the prosecutor takes the matter to court, and the matter is filed before court. Was the accused may be outside through bail or bond. So the accused is going to be brought before court, and the first thing that happens when the accused is brought in court is the pleadings. The pleadings is the process whereby the court is going to read the accusation. So when that person is on, like the police is called the suspect, now he becomes the accused. So when he stands in court, he is the accused. So the court is going to read the charges that has been brought before this person according to the prosecution. So when the charge is read to this accused, so the accused during that charge must be able to plead whether guilty or not guilty. So when this accused pleads guilty, it means that the judgment is going to be made just there. So that means that this person is guilty of the charges or accepts that he committed the crime. Then if the accused pleads not guilty, that means that the accused deny the charge, deny the case, deny that I did not commit the crime. So that is where now court begins. Now, in the criminal jurisdiction, there are three players, just like in any other court. Number one, there must be the jury, who is the judge. So the judge is going to stand, or the magistrate is going to be there to listen to these parties, the prosecution and also to the accused. So there are three players that are there in court: the judge, the accused, and the prosecution. Now, the duty and the work of the judge or the magistrate is to listen to the evidence brought before court. So the judge is going to listen to both sides. So the judge is there to be the middle person who should not have any favor to any parties. Though the criminal jurisdiction has some biasness. What I mean that some biasness is that it says one is considered innocent until proven guilty. But if that is true, why should someone be in custody? Why should someone be reminded? So now the reason why the accused is reminded, because they can run away and they can decide not to appear before court. So the accused is more disadvantaged in court. That's why he needs to be protected by the lawyer. So now we said we have the accused, we have the court who is the jury or the judge, then we have the prosecution. And the fourth person in court is a lawyer to the accused. So now that is where now the court or the criminal court is complete. So now the duty of the prosecution is to bring evidence and to convince the court that this person committed a crime. So their duty is to bring anything or everything to show to the court that the crime was committed. And the duty of the judge or the jury is to look at those evidence and make a decision to look at them. Are they 95%? Are they beyond reasonable doubt? And the duty of the accused is to deny the charge, and to say or to show that the crime was not committed. The crime was not committed. That is the duty of the accused. So, as the paralegal counselor, you remember we are trying to help the client, and we are not the ones who are going to represent this client. Or you are there to bring the evidence and present them to the lawyer, so that the lawyer will be able to speak on behalf of this accused. So the next stage after the pleading, or which is called the plea, when the next stage from the plea is like in Zambia, there is what is called mention. Mention, it is whereby this person is brought before court, and in most cases, when someone appears before court for a plea, it takes 2 weeks. In most cases, then that person has to come and appear before court and for mention. So during mention, the accused is going just to come before the judge and before the court and just appear that he is present, and I don't know the reason for the plea, or for the reason for the mention, why they allow the person to appear before court. But I think it may be that maybe this person has thought through the case and may want to admit guilty or not guilty, or maybe this person may want to make an application. Now, the first time when this person appears in court and is not on police bond and is not on bail, and this person is appearing in person and is appearing, he doesn't have the lawyer. The advice that you have to give this person is that when they stand in court and after the plea, after the case is laid to them, and they deny the case, which is they plead not guilty, then what they have to do is to lift the hand. And when they lift the hand, that is a sign that they have got something to say before court. Now, during that time when they lift the hand, they should apply for the bail. They should ask the court for bail. And the words they should use is that I'm a citizen of Zambia, or who is given the mandate, or I'm the citizen of this country, and according to the constitution, I've got the mandate to have I've got the law give me the privilege of being given a bail. And that person must be able to prove, to tell the court that I am a resident, or you have to say something that is going to make the judge or to grant you bail, which is going to convince the court. For example, I'm a family man, I'm a person of high standing in the communities, and I cannot go anywhere. I've got this property and all this, so that now the jury or the judge is going to know the reasons why you want to have the bail. Now, when the bail is granted, the bail will be granted and or will be denied, because the court has got rights to deny the bail or not to grant you the bail, but they have to give the reasons. And if the bail is denied, then you can apply it through the you can appeal the bail. So that is the procedure that has to be done. So the accused must lift their hands and apply for the bail. So if they do not do it in the first place, when they first appeared before court during the plea, they can also do it during mention. The next stage that will be there is the commencement of trial. So after the mention, there will be commencements of trial. There will be trial. Now, during trial, it is the moment when the accused or when the prosecution now begins to bring the evidence before court to show the court that this person committed a crime. Now, in that, when the prosecution are bringing the evidence, the first evidence that the prosecution they are going to bring is witnesses. The witnesses, the first witness who should be there is the complainant or the complainants. So the complainants are going to stand as the first witnesses, and then the corroborating witnesses. The corroborating witnesses are those people that witnessed or supports the complainant or the victim. So they are the ones that are going to say there to give evidence on what they see or what they know about that about the crime, about what happened, what really happened. So those are the corroborating witnesses. Now, when the witness is giving the testimony before court, first this person is going to be under oath. The reason why this person has to be under oath, this person is expected to speak the truth in court. So he's going to be under oath, and they are going to start now giving the witness on what transpired during or how they were affected or how they were victimized, how they so this is a person who is a key person and the affected person who has been the crime has been committed because of this person. So this person must give witness. We are going to look at when we start looking at cross-examination, and which is there will be the next lesson, how you should cross-examine this person, or how this person can be cross-examined. Then the corroborating witnesses. The corroborating witnesses, they are going to support now the main witness who is the accused. Then from there, after all the witnesses have given testimony before court, then the arresting officer must be able now to summarize what the witnesses were, what the witnesses were saying and giving, and bring in the evidence. Now, the evidence are the things, for example, if there is this person, there is a medical report, then the arresting officer is going to bring the medical report saying this is the evidence. If there were stolen things that have been recovered, then the arresting officer will bring them and prove to the court and that these things are attached to this person. So he's going to conclude, he's going to bring now the case and everything that that happened, how the complainant reported the case, and the statements that were written, and how he called other witnesses were brought to him, and how he gathered information and evidence to bring before court, and how he also interviewed the accused, and how he found that the accused was he was guilty in this in the action that the accused committed. So basically, that is the first thing that happens in a criminal jurisdiction, and that is where now the case starts. So we have talked about from the police to the court, appearance before court, which is the mention, and also now the trial, whereby now the prosecution brings in the evidence against this person. Today we end here. Next time we are now going to pick it from there. What is the next stage? The next stage is when that is concluded, now what follows next. Thank you so much. Join me in the next class. This is your host, Dr. Tulipa Mwanfumbo, and God bless you.